Hello, this is the time and place for the Planning Commission meeting on Wednesday, June 15th, 2011. Roll call.
Planning Commissioner Astorian.
Here.
Planning Commissioner Landrigan.
Here.
Planning Commissioner Lee.
Here.
Planning Commissioner Sheets.
Here.
And Planning Commissioner Yesayan.
Here.
The agenda for this meeting was posted on Wednesday, June 8th, 2011 on the bulletin board outside City Hall and on the city's website. Please join me in the Pledge of Allegiance.
Allegiance to the flag of the United States of America and to the republic for which it stands, one nation under God, indivisible, with liberty and justice for all.
Okay, the next item on the agenda is selection of a chairperson. Do we have any nominations for chairperson?
I nominate Mr. Lee.
Okay, we have a
Second it.
okay, we have a nomination for Mr. Lee. Are there any other nominations? Hearing no other nominations, I'd ask for a roll call, please.
Planning Commissioner Astorian.
Yes.
Planning Commissioner Landrigan.
Yes.
Planning Commissioner Sheets.
Yes.
Planning Commissioner Yesayan.
Yes.
And the newly appointed chairperson, Mr. Lee.
Okay.
It's a done deal. Congratulations. Mr. Lee.
Would you hand that to Greg?
For a moment, Chairman Lee, I was feeling comfortable at that seat.
Okay, let's move on to the next item, approval of minutes. We have 3 minutes because we did not have a quorum in the past meetings. So can we look at May 4th minutes? Yes.
Landrigan.
And this is on the May 4th?
Fourth roll call.
Okay. Oh, yes, yes. You're absolutely right.
Change.
Okay. Any other comments?
I move that we accept the minutes of May 4th as amended.
Support?
Second.
Roll call, please.
Planning Commissioner Astorian.
Abstain?
Landrigan. Sheets.
Aye.
Yesayan.
Aye.
And Chairperson Lee.
Abstain. Okay, move on to the May 18th minutes.
Is there, just for the sake of simplicity, is there a way we can just vote on both of them together if there's no issues?
No, the only issue is I have to abstain from the third one.
Oh, okay.
Right. yeah.
Well,
Okay,
Right.
then we'll do it.
Yeah, exactly.
And chairperson Lee, actually, we don't need to have a vote. All we need is a motion and a second to accept minutes.
Okay.
Sure.
Good.
Okay.
That's quicker.
That way.
I move that we accept the minutes of May 18th.
Second.
Okay. We'll move on to the June 1st minutes. Any comments?
I move to accept the
Okay.
minutes of June 1st.
A motion, support?
Second.
A motion, support. Okay, let's move on to the oral communications. Okay, I see none. Okay, item number 7, zoning appeals. Old business, there's none. New business. We have a conditional use permit case number PCUP 2010-006 and parking reduction permit case number PPR 2010-004. Ms. Toledo.
Mr. Chair, there was a letter that was submitted requesting a continuation for this case. The applicant actually, or the applicant's representative is here in the audience in case you have further questions regarding the request to continue the case. So it's up to the board to decide whether or not they want to continue.
Any comments?
I would like to ask, we have a pretty full agenda for the summer. So how long would this be continued till?
They're requesting I believe, the second meeting in the month of July. I believe that puts them at July 22nd, if I'm not mistaken.
Yes, we already have 2 other appeals scheduled for that evening. So I would probably suggest
20th,
first meeting of August.
July 20th.
Oh, okay. July 20th?
Yeah.
I see that there's, they're requesting for the reasons of some sort of architectural support for this case. Can we get a little bit more clarification as to why the continuance is being requested?
Mr. Chair, you probably should request the applicant's representative to provide additional clarification. That's my suggestion.
Good evening, gentlemen and lady. My name is Derek Taboni. I'm the applicant's attorney. When the request was made, there was an architect handling it who had originally submitted the plans for the, I believe, going back to the original conversion from a appliance store to a restaurant. He was going to address some of the concerns in the denial letter at the last level. I have learned since today that he has not done that and does not intend to do that, so I will supply that information. But I've been in trial the last 2 days, and I haven't even been able to review the recommendations of staff counsel except in this building. So here's what I understand the problem to be, or the concern to be. The conditional use permit for the banquet hall use was denied on the basis that there wasn't enough parking. The conditional use permit for the parking reduction permit for 16 spaces was denied on the basis there wasn't adequate parking, which is, of course, why you submitted conditionally from parking reduction permit. I will address those issues, and some of the other information in both the report and the staff report are incorrect. And I'll have an opportunity to address that information as well and provide the documentation which indicates it's incorrect.
So this documentation you will provide will address and resolve that issue with the parking reduction?
I'm going to try. What we're going to do is we'll probably want to do a traffic survey, particularly if we get a date in August, we'll do a traffic survey. I had done a traffic survey myself, of course. I'm not an engineer, I'm an attorney. But I sat there and watched one of their larger events at night and watched where people parked and see whether it impacted the city and impacted the surrounding community, and it simply didn't. But the staff report indicates there's a problem or there's a concern that even if weekends are okay, that weekdays may not be okay, but they don't have 200 people coming for weekday events. But we will pick a large weekday event and do a traffic survey for that as well, so that we'll have information that, I don't know how much you know about the location, but this is a location on San Fernando Road. There's no night business there at all. Most of my
I'm
clients,
sorry. Mr. Bowen's testifying now. I just, I
That's
think
the
if you clarify your reason for the thing, I don't want to get into the merits of the case here.
Now, we do, as a board here, could hear this case if we feel that that there's enough evidence here to hear the case, or?
Mr. Chair, members of the commission, the matter is fully prepped. There's a report. The report went out Wednesday of last week, or Wednesday? It's been a week, I think, that the report's been available to the public. So there is the ability for the commission to move forward and hear this case. It's up to the commission to decide whether it feels that the additional information that Mr. Taboni wants to prepare would add to the value to the hearing and the commission's decision.
I don't see any public here for this case here. Commissioners, what?
Who's this?
Mr. Chair, if I may, to be frank, we have a long-standing business in the community that's been in business for 15 years. I think they deserve to have this little bit of leeway from us for them to be prepared and come back. I personally had done some work on it and so forth, but I think they deserve to have that. So I'm okay if the rest of the commission that has seniority over me is okay with it too.
Okay. My first question now is, you said you worked on it,
Yes.
on this case?
Yes.
My other question is that,
Let me clarify. By work, that means that I was told that this commission comes to meetings well prepared, so I had to do my own due diligence. That's what I mean by having
Working on it now.
That's right.
Not a problem. That helps.
If
That's
I did not
fine.
want to make the inference that I know the attorney or the appellant. I don't know any one of them. So.
Thanks for the clarification. That makes it very clear. The letter about the continuance is dated May 25th?
Correct. Based on what the architect contacted me and told me he wanted another month essentially to submit more information. I just found out today that he isn't going to do that. Somebody else is going to have to. I'll take the responsibility. I will get it to you. But he figured it was going to take him some more time anyway.
So he's going to do work, architecture work relative to the parking issue that we're dealing with tonight?
He was going to provide additional information which he thought would be relevant and appropriate. I don't know exactly what he was going to do. We didn't discuss it. I had left the details of that up to him.
Chair, in reading this material, I probably felt that it couldn't get any more confusing, but I'm thinking that if we go forward, it probably will.
Yes.
But I have some issues about taking another step in trying to clarify something that what I'm reading is there's an illegal action, a legal activity going on now, or at least a use issue now, and we can't make the parking with that. So I think there's enough here to work with. I'm not sure that's going to change much with one extension or one continuation. That's the sense I have right now without going into doing the deliberation right now. I don't know how everybody else feels.
Mr. Andrew?
Oh, I was. Feel that it would be. Sorry, that I would be beneficial to have a real parking study that is done by a valid parking company to substantiate that. I think would be to the advantage. If it's going to be Mr. Taboni out there again counting cars, I would be really disinclined to extend it. I understand that it could be fun, but I doubt you had a good time doing it. So unless I really am convinced that we see something different here, I agree with Mr. Sheets. But if I think there's going to be a real substantive parking study, then I would be inclined to vote to allow that.
That's our intent.
Mr. Sen?
I would be okay continuing it. I know the applicant had sufficient time to do this, had enough get the information that they needed. But I can't make the decision without hearing their testimony. So one continuance is okay by me, and if we can get a better traffic study, that would be a good idea as well. That would help this case make our decision much easier.
So my question to you then is that the study would that entail professional study, traffic study?
You made it real plain you don't want me to do it again, so I will have a professional do it. Remember, I wasn't intending to do this myself.
Right.
I thought the architect was going to take care of this, and I come here today finding out that no, he hasn't, and he's not going to. So that's why I'm requesting the continuance now. I will make sure it gets done. I won't trust anybody else to get it finished.
Okay. I'll take the motion then.
I move to continue the conditional use permit case
To a date certain.
to a date certain, or August the
We would
first.
suggest the first meeting in August, which is August 3rd.
The first meeting of August, which is August 3rd.
Okay, support?
Second.
We have motion and support. Roll call, please.
Yes.
Yes.
Yes, with the terms of having the professional traffic survey done.
Yes.
Aye. So 405-0, it is continued.
Thank
Today's
you.
May I
certain.
ask a question,
Yes.
Mr. Chair? Mr. Garcia, did we need to have that condition in there for the continuance for it to be valid?
No, although I'm not, even if it was a condition, I'm not really sure if they don't do the
It has
study.
no
They still will
weight.
have the hearing on that
Okay.
day. You guys will just be able to take that into consideration.
Thank you.
And if I may, we normally encourage people who are conducting parking studies to work with our transportation staff to set up the parameters of it, just so that it's as useful as it can be to you.
Do you have engineers you know? This is not,
We can discuss this tomorrow.
we'll call you tomorrow then?
Yeah.
And I did want to clarify that that's without further notice, correct?
Without further notice.
Without further
Thank you.
Thank you, Mr. Foy. Okay, moving on to the next item. It's a tentative parcel map number GLN 1625. It's 2246 to 2248, Raphael Terrace. Mr. Hamilton.
Mr. Chairman, members of the board. What is proposed is a parcel map to create two single-family residential lots. You have already considered this proposal in the past. This commission recommended denial. It went to City Council. At City Council, Mr. Danielian asserted to Council that he could provide new information that this commission hadn't heard, and so the City Council remanded it back to you. That's why it is back here before you in somewhat altered form. So what I've done is I've posted both the old parcel map and grading plan, the new parcel map and grading plan, and then one of the elevation or sections and an elevation for the old and the new house plans. Just to sort of briefly summarize, the bulk of the difference is that in the old plan, Mr. Danielian was going to tuck the garage under the house, making this a two-story house under the code. That was inconsistent with one of the hillside secondary ridgeline criteria. In the new plan, he's got the garage at the same level as the living area, so it's a one-story house that makes it compliant with that one criteria. The effect of this change also means that there's less grading in the new plan than in the old plan. A total of 3,200 cubic yards of cut in the new plan, as opposed to 6,580 cubic yards of cut in the old plan. The shape and boundaries of the parcels, as you can see, are roughly the same as in the two plans. The size of the parcels is not really changed, and the location of the pads for the houses on the two parcels has not substantially changed. Also for your review up here on the board are some aerial photographs that denote the boundaries of the site, and a map showing the boundaries of the secondary ridgeline as it pertains to the site. And as you can see from this map, virtually the entire site is within our secondary ridgeline, or one of our secondary ridgelines. This project was originally submitted, this current application was submitted in September of 2008, but that's not really the beginning of the history of the project. This has been approved, a subdivision on the site has been approved both in 1993 and in 2001. Both parcel maps were ultimately expired and are no longer valid, so that's why there's a current application before you. At the Planning Commission meeting of December 2nd, 2009, by a vote of 3-0, the Planning Commission denied the application. The applicant appealed, as I mentioned, and it went to Council in February of 2010, who remanded it back to Planning Commission. The applicant has been working with staff since the September 2008 time to work through the variety of issues here to bring it before you. The current version of the plans were submitted formally on August 4th, 2010. The total site is 3.13 acres and would be divided into lots of 31,000 and about 105,000 square feet. There is single-family development all around the property except to the east, which Immediately adjacent is the freeway, and then across the freeway there are some more single-family development. To the south of the project, as you can see in the aerial photograph, is the large condominium project on Alpha Road. Parcel map applications must show that there is some consistency with neighboring properties. To quote, "The proposed lots shall be of such width, area, and design as the Planning Commission or on appeal the Council finds to be necessary to preserve the purpose and intent of this title and of Title 30 and to comply with the general plan. The area, width, and design of such lots shall be determined by the average size and dimensions of lots within the same zone and general plan designation within 500 feet. It is, after evaluating the project, we believe that the applicant has in fact demonstrated that the lots are of a size that is compatible with neighboring development. The applicant has, as a result of this being a parcel map, the applicant has been told by fire that there will have to be some sort of turnaround provided for the property. There is no feasible way to install or build a cul-de-sac, which we would normally require. So as a compromise, the applicant has proposed, and fire department has accepted, and our engineering department has accepted, the proposed hammerhead turnaround on the westerly corner of the site. The odd part of this is that some of that work would be off-site. It would be on the neighboring property. Now, he has proven that he has agreement from the neighboring property owner to do this, and in fact, the parcels have already shown alteration at the assessor's office to accommodate this change. But it does appear that based on the most current version of this plan, that off-site configuration will have to be altered, and so the agreement with the neighbor will have to be altered to accommodate the current design of the turnaround. You can see that the turnaround shape is somewhat different and somewhat larger on the right in the current plan as compared to the old plan. One of the objections to the 2008 submittal was the taller two-story proposal. As I explained, the applicant has made this a one-story, and one of the beneficial results of this is that the grading will be reduced. It's worth pointing out that the amount of grading will change very little whether there are one or two houses built on the site. It will not change very much. It may not be very little, but will not change very much because the substantial portion of the grading is simply punching the driveway through the berm that rises very steeply above Rafael Terrace. You'll have to do a deep cut through that berm to get this driveway in and up onto the pad level. Now, if there's only one house proposed as opposed to two and no subdivision, then the fire department has indicated they could not require the turnaround. So the off-site grading would not be required to provide turnaround for fire vehicles or garbage trucks. So there would be some potentially significant reduction in grading by not having that there. The primary issue related to this project is the fact that it is in a secondary ridgeline. The secondary ridgelines were shown on maps created in 1993, and there are a set of development restrictions found in the municipal code. Development in general is prohibited in secondary ridgelines, it's worth pointing out. And it is discouraged in secondary ridgeline by the city's hillside design guidelines, and also by policies in the open space element of the general plan. The Planning Commission, however, may permit development within the secondary ridgeline areas if it is found that the strict application of this section prevents reasonable development due to the size, shape, or location of the parcel or the necessity for public street access. If the Commission decides that the project meets the standards of the hillside guidelines and the hillside secondary ridgeline ordinance, it must also conform to the following criteria in the secondary ridgeline. Manufactured slopes limited to a maximum steepness of 1.5 to 1 and a height of 25 feet. Retaining walls limited to a maximum height of 5 feet and no more than 2 successive retaining walls, provided that they are separated by a minimum of 5 feet with a maximum of 2 to 1 slope between the walls. Crib walls or successive crib walls limited to a maximum height or combined height of 15 feet. Structures limited to a maximum of 15 feet or 1 story in height. Grading and structures to be located as far away from the crest of the secondary ridgeline as possible, given the physical limitations of the property. Grading and structures must be consistent with the intent and purpose of the hillside design guidelines adopted by resolution, and a naturalizing landscape palette as found in the landscape guidelines for hillside development. The grading plan shows one-to-one manufactured slopes within the street right-of-way, the proposed dedication of the street. This is contrary to criteria 1 of the secondary ridgeline. However, this is the preferred alternative by our city engineer's office as a way to avoid the construction of retaining walls within the public right-of-way that would then have to be maintained by the city engineer or the city. The current plans show one-story residence, and the houses are 16 feet tall rather than the 15 feet specified in the hillside criteria. They are, though, low-scale houses and one story in height. It is probably feasible for the pitch of the roof to be altered slightly to meet the 15 feet rather than having them be 16 feet tall. The proposed grading is essentially on the crest of the ridgeline, which is contrary to criteria 5. However, it is important to point out that most of the site has been graded years and years ago. It's unclear exactly when or how it got graded, but it clearly has been graded. So the site is disturbed. It's not natural, and the pad area for the houses is not in any way natural. There are no trees on the pad. There are very few shrubs, very few scrub weeds, and that's it. Given the existence of the pads and the constraints posed by the steep slopes elsewhere on the site, the ridgeline and these pad locations are the most suitable locations for the new houses. The proposed grading will be consistent with some, but not all of the hillside design guidelines mentioned in criteria 6. The graded slopes cover small areas and will not be visible from very far from the property. The proposed house pads are clustered, which is one of our guideline standards. There's a common driveway, although each lot does have a flag and is of the appropriate width to meet the flag lot standards. This minimizes the amount of grading. The one-to-one cut slope in the right-of-way will rise 14 to 16 feet above the street in one continuous slope, and that is generally discouraged by our hillside design guidelines. It'll be directly visible to the street, not behind the structure, and will contain no variation. The slope behind the turnaround required by the fire department will also be in direct view from the street. It'll have a constant 2-to-1 slope, and it rises about 15 feet above the turnaround pad. These characteristics, again, are contrary to the recommendations found on pages 3 through 5 of the guidelines. The plans do include a landscape palette that is consistent with hillside design standards. The applicant has submitted a digital model, and we have a physical model today. I have reviewed both the digital model and the physical model, and I believe both are reasonably accurate representations of both the hillside, the grading, and they're not proposed houses, but the houses showed on the plans. These are not necessarily the houses that will actually be built. They're just a way to demonstrate that houses compliant with the code could be built on the property. And I think the models, both the physical and the digital, accurately represent what could happen. The project does not appear to require any of the other variances that it has required. Other versions of this application have required in the past. It will be subject to a conditional use permit. Development of the site would be subject to conditional use permit and to the design review board should this commission choose to approve the project. So to summarize, the project is consistent with secondary ridgeline criteria 2, 3, 4, and 7, and with 5, given the physical limitations of the property, but it is not consistent with criteria 1, although that is the preferred alternative by the city engineer. and the project is consistent with some but not all of the criteria of the Hillside Design Guidelines of Criteria 6 of the secondary ridgeline. The Planning Commission has the authority to approve the proposed subdivision with the waiver of one or more of the secondary ridgeline criteria and to exempt the project from one or more of the standards of the subdivision ordinance as provided by the following language in the municipal code. It is realized that certain parcels of land exist of such size, shape, location, topography, subject to such title restrictions, and sold and devoted to such usage that it is impractical for the owner to conform to the rules, regulations, and standards of this title when divided or subdivided. In such cases, the Planning Commission or the Council may determine that conditions affecting the property in question warrant and require that exceptions be made. Provided, however, that no exceptions may be made to any requirement imposed by the Subdivision Map Act and shall not have the effect of nullifying the intent and purposes of these regulations. No exception shall be made unless the Planning Commission or the Council makes a finding or findings in writing that such exceptions are necessary, stating the reasons and grounds thereof. This project was reviewed. A negative declaration was prepared for the project back in 2000, and that was adopted by the Commission in 2001, by the Environmental Planning Board, in fact, in 2001, and staff does not believe that environmental circumstances have significantly changed or that new environmental documents need to be prepared. The key issue in this case, really, for the last few years has been whether this is consistent with the intent of the city as regards to hillside development. Not merely the listing of the detailed criteria, but the intent. The intent of the hillside, of the secondary ridgeline criteria, is clearly that development should be discouraged in secondary ridgelines, and only that which is necessary to allow for reasonable development should be approved. The property is zoned residentially. A single-family house is allowed essentially by right, subject to design review and conditional use permit processes. A subdivision to create two house sites is not required by right. This is a proposal by the applicant that is subject to your discretion and the city's discretion. And staff does not believe that this project represents sort of the minimum necessary reasonable development of the site and would require the exceptions to be granted in order to approve the development. We think it is much more the intent of the code that not two houses but one house maximum be approved on the site. You do have the authority, as I've said, to approve the project with appropriate findings, making the various exceptions necessary to the secondary ridgeline criteria, and exceptions to an on-street parking bay requirement that is mentioned in the staff report but that I haven't gone into. If the Planning Commission prefers to approve the project, we recommend that the hearing be continued to allow the Commission and staff time to work together to draft the necessary findings. That concludes my staff report, and I am ready for any questions.
Any questions? Mr. Sayed.
Since it is on secondary ridgeline, and if they did go back and just propose one single family, that's going to be coming before us anyway, right?
Not necessarily. If they can propose it in such a way that it is consistent with the secondary ridgeline standards, I don't believe it would have to come back before this commission.
Okay, and that's below the, I guess, the required, whatever, below the requirements under the Hillside Design Guidelines.
Right.
Right.
But I would actually defer to maybe Mr. Garcia as to whether if he submitted an application for a single family home that staff found was in compliance with the secondary ridgeline criteria, would it still have to come back to this commission for a finding of consistency?
It would. In fact, Mr. Chair, members of the Commission, I think that all development requires Planning Commission approval for any project within the secondary ridgeline. So whether it's grading, development, or housing construction would require Planning Commission approval in the secondary ridgeline.
Thank you, Mr. Garcia. Any more questions? Yes, Mr. Andre.
This site. since we are making reference to off-site grading in reference to this site's grading, would that grading calculation, since it's not on this property, be part of this calculation? Can that be done?
It would still be, we would consider this as part of the project. It would still, even if it's off-site, it's still part of the project and would still have to.
Project-specific, not property-specific.
Absolutely, because there still would have to be trucks involved to take that material someplace, and it's part of the project impacts.
I have one other question, if I may. You mentioned that the applicant was had been dealing with the assessor, and that they had an agreement. Is that an easement for this? Would it be a shared easement? Do you know what the legal document is that they are proposing that would satisfy the city's requirement for that turnaround?
I'm sorry, I don't know that those details. Perhaps the applicant can clarify that.
Mr. Chair, I have a couple of questions. First, housekeeping. On your staff report, page 3, last paragraph, you have 3-0 vote with 1 abstention. Where is the 5th? Yeah, okay. It says 3-0 with 1 absent.
Could have either been an abstention, or we might have had only 4 commissioners at the particular time.
I'd have to do the research to find out why.
And then on your page 4, there is reference to new evidence. What was this new evidence that was used to either approve or remand?
Well, Mr. Danielian asserted that he had new evidence, and he was primarily focused on our objection to it being a 2-story house. So he revised the project to show 1-story houses on the site, and that was his new evidence, that he could revise the project to make it 1-story instead of 2-story. There is no other new evidence per se.
And if I could, Mr. Stern, I believe, and Jeff, you can correct me if I'm wrong, the council remanded it, but it was at the director's recommendation to remand it back to the council, back to the commission.
Your memory is better than mine. That it's quite possible that Hassan made that recommendation.
Yeah.
Mr. Chair, I have 2 real quick ones.
Yes,
Your
Mr.
staff report designates the average slope of about 51 to 53%.
Yes.
Yet the subdivision map shows that 38 point some percent. Which one is the one that we have to look at?
The subdivision map shows 31%.
38.45% in the TTP, in one of the underlines. Maybe I'm reading it wrong.
I'll have to ask the applicant's engineer to clarify that figure. I came up with the figure, I believe, by using our city's GIS. It is not definitive. If the applicant's engineer came up with a calculation that meets our formula, then we would defer to his evaluation, his number.
Thank you.
Any more questions for the staff? Okay. I have 3 public cards here. Are these all part of the applicant, or?
The first 15.
Okay, so Shogig, Premium.
Good afternoon, Mr. Chairman, members of the Planning Commission, Shorik Yepremian Consulting. Congratulations to Commissioner Astorian being appointed to this commission, and Commissioner Lee for the chairman position. I'm here representing Mr. Sam Danielian on this project. I was not involved in any of the previous applications. I'm not the applicant or was involved in this case in any way except to be here and represent his case. This is not a new project. This has been going on for the last 22 years. I was surprised to look at the file and go back to all the old documents, and Jeff did a pretty good job in his presentation. But I would like to focus on is basically some arguments or some points. I'm not going to get involved with the details of the project. Sako Marcusi, who's the project architect, he's here today, along with Haik Martirosyan, who's the project engineer. They've been more involved in this project than I have been. But what I would like to focus on is the historical information. This project started back in 1989 when my client purchased the property. He proposed a 3-lot subdivision. in the early 1990s. That was his first version of the project. In 1993, the project was approved. 1999, unfortunately, it expired. So this is what happened throughout the 1990s. So it was approved as a 3-lot subdivision in the 1900s, even after the Hillside Ordinance was in place. In 2001, a new parcel map application was filed for a 2-lot subdivision, which is this version. Staff recommended approval to Planning Commission at the time, and Planning Commission approved that application as a 2-lot subdivision. In 2005, the Planning Commission further approved a time extension, and Planning Department recommended approval as well. But in 2007, the project expires again, after my client working so diligently trying to meet all of the conditions of approval. After having reviewed the case file, I do respectfully disagree with staff's recommendation for denial for this application, since the project was approved before at least 2 times, with time extensions given in 2005. And throughout this time, he worked with all of the conditions and requirements that you see in front of you today. The second point that I would like to make is the fact that the Environmental Planning Board back in 2001 adopted a mitigation measure for this project. Every project approval is based on CEQA review, California Environmental Quality Act, especially when it comes to hillside development. And this has been true since the state established CEQA guidelines. Staff for this application review, in their current staff report, determined that they will use the 2001 environmental documentation that's in the file today. Staff indicated in their staff report that environmental circumstances have not changed significantly and that previous environmental document still applies. In 2001 staff report, which you should have in your file, the staff report to EPB indicated that impacts on aesthetics as a result of the proposed development are considered less than significant. Impact on soil erosion with proposed grading and new development is considered less than significant. The staff even acknowledged in that environmental review that the site is on secondary ridgeline, but they had no environmental concern. No other environmental effects were found to create potentially significant impacts as a result of the proposed project analysis and preparation of the initial study, and that initial study should be available in the file. I reviewed the initial study. There is a section on land use and planning, and it asks if the project conflicts with any applicable land use plan, policy, or regulation of an agency with jurisdiction of the project area. The check mark is no impact, so it does not refer to any hillside ordinance, secondary ridgeline. The initial study showed no impact. So basically, I would argue that the environmental documents that are in file today are valid, as staff indicated, and there's no impact to the environment or the neighborhood. I drove by the property the other day. I lived in the neighborhood 10 years ago, and there was absolutely no change in this neighborhood. There were no new developments in terms of single-family housing, no roadway construction. The site conditions haven't changed. So the question this commission should ask, what has changed from the 2001 approval, from the 2005 Planning Commission granting extension up to 2007. So the question is, from 2007 to now, what has changed? And you can see from the records that nothing has changed in terms of environmental review. Third point is Design Review Board. The lots, the prior version, which included the 2-story plans, was approved by the Design Review Board in 2007 based on the Planning Commission's 2001 approval. Again, Design Review Board's authority is to make sure the houses are compatible with the neighborhood, they meet the hillside design guidelines. The project was approved. Unfortunately, at that point, the map expired in 2007, so therefore design review approval expired as well. Number 4, general plan and zoning laws. The question you should ask, has anything changed since 2007 expiration? The general plan elements, they haven't changed. Yes, there were some minor amendments. The zoning laws haven't changed. The last change to hillside ordinance was early 1990s. So nothing much has changed. Subdivision laws. Nothing changed since 2007, 2005, 2001. Actually, the state even issued extensions to subdivision approvals in 2008 due to the economy. They wanted to allow more time for developers, property owners to prepare their maps and get all their conditions and approvals in place. In 2008, I believe, staff can correct me, the state also issued 2-year extensions. So if my client's application didn't expire in 2007, he would have still been active in terms of the map. But he could not take advantage of the law, and therefore he had to do another filing. Neighborhood opposition, as you can see in your files, there were no neighborhood opposition in the past, and we don't see any neighborhood opposition today. Yes, there will be some issues in terms of construction during limited period of time, but again, it's just for construction period. Cost to my client. This has been going on for 22 years. Obviously, my client spent a lot of money trying to file. He filed several applications, several extensions, appeals, and so forth. But he also made a lot of compromises. His initial proposal was a 3-lot subdivision. He now proposes a 2-lot subdivision. He dedicated the 3rd lot to the city as a public open space. He minimized grading. He lowered the building height from 2-story to 1-story. He provided fire code requirements with the hammerhead. He had agreements with the neighbor to provide that. So he made a lot of compromises to get to this alternative. What else? Let's see. I would like to basically conclude by saying that in 2005, when this commission granted a time extension until 2007, in their findings they have indicated that, quote, conditions in this neighborhood of this parcel map have not changed to warrant reconsideration of the original approval. The second finding was that the findings made by the Planning Commission in the decision of November 19, 2001 remain applicable today. So they even went back to say, with their 2001 approval, basically nothing has changed. And I would like to give you a copy of that motion. So I think the commission today should ask the question, what has changed in the 1990s? What has changed in the 2000s from 2001 approval, Planning Commission granting extension until 2007, and from 2007 to now, what has changed to make this project any different? We therefore respectfully disagree with staff's recommendation and hope that you take into consideration the project's approval history, conditions that apply to this property, and current laws that are in place, which all direct to the fact that this project should be approved today. Thank you for your time and hope you reconsider staff's determination. And as I said, I have the project architect here today and the project engineer if you have some detailed questions about the project.
Any questions
you.
for the applicant?
Yes, I do have a couple of questions. Mr. Permian, why the extensions other than the recession, 1990 and 2000, the dot-com? Why the extension? Why not go ahead and when you have something good in your hand, why not build it?
That's a good question. Perhaps the owner can answer, but I asked him the same question. I think during one time he had issues with his engineer. He switched engineers. And usually with conditions that are in place with any project approvals, there are things when it takes more time than necessary. Recordings, for example, in this case, meeting with the neighbor, agreements, engineering questions. Yeah, maybe he can answer.
I'm Sam Denelian. My address is 557 West Glenox, Glendale. To answer to your question, why we extended, the first time it was 3 lots which was approved. And somehow the engineer delayed the design. The design mainly complication was coming from the engineering. So by the time we fixed that, and then we always had disagreement between engineering and planning department. Always. It was the case. So the planning department was asking this. So my engineer was asking. Anyway, I want to make it short. So disagreement was between planning and engineering. And we have a lot of proof for that one. This was for 3-1. And then we changed the engineer. So we got hired one of the best engineer in Glendale. And also we got the architect, one of the best architects. And then we redesigned the whole project. And the second time when it was approved, second time. And the delay extension was, again, between planning and engineering. The engineering always was giving okay. The planning was somehow they were doing different things, and they were disapproving, and the project was keep delaying, and the engineer was crazy already, didn't know what to do and how to design this project. So we've been working on this project more than 20 years. And like I said, I got the best engineer and best architect, and you cannot design this more than, better than this one. Okay, that was the main reason, the disagreement between planning and engineering. And finally, the last time when we were appealed to City Council, Mr. Hassan said, just go back, let's work with the planning department, and we did work, and there is no issue from engineering and planning at this point. So everything is designed and per planning requirement and per engineering requirement. So in 2007, we already got the grading permit. We already paid for the bond. And the planning department, for your own information, and Mr. Garcia knows that. And correct me if I'm wrong, Mr. Garcia. We pulled up grading permit, and we got electrical engineering and water power, and we got approval, and we paid more than $10,000 for the bond in order to start the project. And as a matter of fact, I went to the building department. The building department approves my plans for 2 subdivisions. And I came back to planning department to get the planning department, Mr. Hamilton's stamp on it. And Mr. Hamilton did not stamp. Somehow, purposely or not purposely, they delayed the project in order to be expired. And after the expiration, and I had some health problem, and I didn't want to pursue, and I didn't want to take legal action, because I had some health problem. So what I did, just
sir,
frankly...
I'm sorry, I don't mean to cut you up, but you don't need to explain. I just wanted to know...
Mr. Asturian, I know. I want to explain that you will know the bottom of this project,
and
what's
I got
happening. Okay, because none of you knows what happened last 20 years and why we end up here. In 2007, I had the project, like I said, I paid the grading, I paid all the bonds, and still, somehow it was a game or whatever, so they delayed the project. And when I had a meeting, and Mr. Garcia was there with the planning, they told me, Mr. Denelian, you don't have to appeal or file legal action, this and that. Just resubmit the file. Nothing has been changed, and you will get the approval again. And I did resubmit, and I didn't do anything. And after that, they denied the project. And there is no reason for the denial. There is no logic to deny this project.
Thank you, Mr. Denelian.
Thank you.
Any more questions?
I have one more question for Monsieur Premian.
Okay.
So how is it that you made a reference to CEQA and the findings of under the CEQA that there was no impact, and that was 2001. So how is it, and I understand CEQA, the relevance to any kind of development, so how is it that that should be reconciled if there is contradictory issues, whether it's design or shape or what have you, under our hillside ordinance? How is that going to be, how do you reconcile that?
Basically, CEQA review is the initial review in any project. CEQA review determines if the project has an impact on the environmental. And if it does, what are some of the mitigation measures to make sure that the project complies? What I was trying to argue that in 2001, not only staff but EPB looked at the environmental documentation and determined that there's no impact to the environment. Staff, in their current review, this is a new application after 2007, determined that 2001 approval is sufficient, that there are no changes to the environmental, there is no impact with the proposed project. So my argument is, if that's the case, why the decision changed from the 2001 planning staff decision to Planning Commission to recommend approvals, and now with their decision to deny the project. In terms of environmental review, nothing has changed, and as a matter of fact, they used the same documentation. They didn't ask for a new environmental review, which is the EIF document to be filed along with a new application. So if they made that determination to make the 2001 environmental document as a valid document and the decision as a valid decision, then their current decision to deny, to propose denial or to recommend denial to this commission is contradictory, in my opinion. Otherwise, they should have asked for a new environmental document.
Thank you. Mr. Landrigan?
Mr. Permian, one question. If one realizes that certain elements were not taken in the first time, isn't it the obligation of the city in the second review to bring those up, even though the initial study, which is actually a federal requirement and not, it's a state and federal requirement and not a city requirement, and that the city is obligated to fulfill its obligation and its governing issues and governing documents. So if in a review it was found that the hillside ordinance and our secondary ridge guidelines had not been interpreted correctly in the second interpretation, it would be to the city's advantage that the planner change that if it's a second review.
What's the question?
Well, the question is that if it's a new application and there's new eyes and you find new evidence, it's the obligation of the city to interpret it in a manner that it's probably maybe more consistent with the project. So
right, but that evidence was there when they prepared the environmental documents in the 1990s and 2001. So hillside ordinance has been in place, design review guidelines has been in place. So the documents and the laws were already in place. So when they reviewed the 2001 environmental documents.
Okay. I'm not discounting that. I'm just saying that new sets of eyes sometimes see things differently, and they bring up oversights, and so that's not necessarily discounting the initial study. It's just interpreting it in a different way.
A lot of times with new applications, if there's new evidence or changes to the previous documents, staff in the past asked for new environmental documents or new EIF application. But in this case, again, they didn't, so they relied, their information is based on the 2001 environmental documents.
All right, thank you for that clarification.
Any more questions?
Mr. Chair, one more question. I'm sorry, Mr. Yeprian, one more question from you. In the staff report, the conditions, well, not the conditions, but the criteria and it's numbered between 1 and 7 on pages 5 and 6. And I understand that number 1, there may be a mitigating factors for it and so forth. But assuming, how are you going to meet the rest of these criterias? How is that going to work with your project?
I think as staff indicated, that the proposed grading, for example, will be consistent with some but not all of the hillsides of 6, criteria 6. Is that the item, Jeff?
I think 1 and 6
Yes.
was.
Yeah. Perhaps Hike can answer that in terms of slopes, and maybe he can answer that more detail.
Well, yeah, Mr. Martirosyan.
Good afternoon, Mr. Chair and Commissioners. My name is Haik Martirosyan. I'm tract engineer. My address is 1545 North Verdugo Road, Glendale. To answer Mr. Commissioner's Astorian questions, we have met all the conditions of secondary ridge line, 1 through 6. I can go one by one. Condition number 1, criteria number 1. Manufactured slopes limited to maximum steepness of 1.5 to 1. We are providing 2 to 1 slope rather than 1.5 to 1. And it says at the height of 25 feet, we are within 15 to 20 feet. That's the only place that we providing 15 to 20 feet of 2 to 1 slope, which covers the hammerhead. Within our property, everywhere is 2 to 1 slope, and we are less than 10 feet height from top of the slope to the bottom of the slope. So we are meeting this criteria number 1. There is no 1.5 to 1 slope. Number 2, retaining walls limited to maximum height of 5 feet and no more than 2 successive retaining walls. We meeting these conditions. We have, if you look at our grading plan, you will clearly see that we are meeting that criteria number 2. Criteria number 3, creep walls. They allow us to put the creep wall up to 15 feet. We are not using creep wall. We're going with the regular retaining wall and with the slope. Number 4, structures limited to maximum of 15 feet. Our architect has designed it for 16 feet, and we believe that we can work around that to bring it down to 15 feet to meet this criteria as well. Grading and structures must be located as far away from the crest of the secondary. The pad is already been created long time ago. The entire pad, the flat area of the pad is the crest of the secondary ridge. We try to move it as much as we could to get it away from the crest. That's what we start our grading from the, I believe, right at the property line by providing successive retaining walls to bring that grades a little bit further away from the crest. I believe we already meeting this criteria number 5 also. Given the physical limitation of the property has already been, as I said, graded, and there is a flat pad created long time ago. Number 6, grading and structure must be consistent with the intent and the purpose of the hillside design guidelines. We have provided a grade. The only place that we are grading extensively is the entryway to our property. If you look at the site, there's a big vertical cut, almost vertical cut right at the northwest corner of our property. So no matter what, if we want access to our property, we have to grade that portion. By grading it, we are trying to minimize the grading by having only 5 feet retaining wall around it. We talked to a city engineer. They were asking us to provide a 1-to-1 slope because right now the existing slope is steeper than 1-to-1. If you look at standing in the street and looking straight to those areas, you will see there's a 15 feet or 16 feet high cut. Even by grading that portion, you will still have that 16 feet cut visible from the street. So we are not changing any visibility of that cut, except we're making it better. It's steeper than 1-to-1. We are creating, it's steeper than 1-to-1. We're coming back to 1-to-1, which is what city engineer is asking us to do. We propose to build a retaining wall so we can comply with 2-to-1 slope, but they said no, there is a maintenance problem with the city, and the city does not want to maintain that retaining wall. So we have that approval from city engineers. Again, to go back to the hammerhead portion, if you look at again from the street, looking at the area that hammerhead is going to be constructed, you will see the top of the slope. That top of the slope is not going to change. We're still going to start grading from that top of slope all the way down to our driveway to provide that hammerhead. So that top of the slope is still going to be visible from the street, much better than what we have right now, because it's a vertical cut and we have 2-to-1. We are proposing 2-to-1 cut. So I think we are meeting all these secondary ridgeline criteria, and I don't see why that still city, the planning disagree with our work. We have worked with them for last, I would say, 3 years just to revise these conditions that they are asking us to do. And I think we have done a pretty good job, and we're meeting all these conditions. If you have any questions, I will be more than happy to answer.
Question?
Mr. Chair, I would like us to have a chance to look closely at the model.
Sure, yeah.
Okay, thank you.
I guess
Would the commission like me to bring it up to you?
Yes, yeah. The pianos.
Well, I sort of like to walk around them. Vanna Hamilton.
Thanks for that. Mr. Hamilton, there was a reference to a digital model.
Also. Is the digital model available on a screen or something?
I can relatively quickly pull it up for you while you're looking at the physical model, if you'd like.
That would be great.
Sure.
Right, here's the street. Actually, this is the
That's
street.
that, yeah.
Back
the
up.
hammerhead, right? This is.
Shanaz, can you pull the screen down and turn the projector on too, please?
See, this looks like there's a lot more room really on the plan. It's not very clear.
Suppose you to be able to hear what you're saying, or
Don't we have a mic?
Doesn't just speak loud enough so they
Okay.
can hear you. Just because it's hard.
But this model is hard to see if it's exactly representative of the exact plan.
Well,
See how this comes up to the edge.
Right there.
Well, Jeff.
Oh, well, this I guess that is
it
the
is.
property line.
Yeah, Jeff says that
Okay.
it's pretty good representation of what it's about.
Right, yeah.
Well, I think you're all smart enough to see that for yourself when you compare the proposed new grading plan with the model.
Yeah.
I think it's reasonably accurate. I haven't tried to put a scale to the model to.
When you're looking at the property line right here, then you can see the similarity.
It turned green, Laura? Did it turn to green?
Great.
Careful.
It was the hillside.
There's that hillside. There goes the neighborhood.
On the TV screen, you can see the animation of the model.
Well, that's there's the slope so high.
Kind of like the old TVs, has to warm up.
See if you recall.
Mr. Foy, for reference for the public, and I say this because I'm not a technical planner, the slope going up on Mountain next to Glendale College, that's a 2-to-1 slope, or is it about, would you say?
I couldn't tell you. I'm sorry.
That's 1.5 to 1? Okay.
In an earlier version of, I think in the 2001 version of this project, they were proposing some parking between the two houses. That is no longer being proposed. They're providing all the parking in the garages themselves. I made mention of an exception that would have to be granted related to parking on the street. The improved width of the street is simply not wide enough to allow on-street parking, so if you were to approve this subdivision, you would also have to grant an exception from the standard that the street be widened to allow for on-street parking.
Yes, Mr. Andre.
There is essentially, in this current version, there's no room, no place for guest parking.
When there's shared driveway, is that also something that has to be agreed upon and put into the subdivision map act? So that
Well, it would be part of the conditions of approval. Should it get to that, should you choose to approve it, the widths of the flags and the width of the driveway does meet code.
Okay.
So that's not a problem. We would have conditions related to CC&Rs for joint maintenance of the driveway. If that was something we've done recently on the Deer Pass project that had a similar situation and other joint driveway situations.
And the other question, on the hillside ordinance, there's a minimum frontage. Since it will be 2 lots, is the minimum frontage doubled, or is it a single? How is that addressed?
Well, if they could, they would design this with 100-foot minimum frontage for hillside lots. But it is my opinion that they have designed this as 2 flag lots, and the flags meet the minimum width necessary to conform as flag lots.
Okay, thank you.
Mr. Hamilton, the city engineer preferred to have a 1-to-1 slope versus having the retaining walls, so it would not be maintained by the city of Glendale. An obvious question was, why can't you ask the applicant to do the 2-to-1 that they were thinking about, and also do a covenant with the land that they also maintain the grading walls?
I suppose that's potentially possible, at least in theory, but I would defer to Mr. Garcia as to whether legally we could, impose that or enforce it over the long term.
This is the first time I think I'm hearing that the city engineer preferred to have a retaining wall in the right of way.
Not have the retaining wall.
Oh, okay. Because I was going to say that's part of the reason they prefer not to have retaining wall. Even though we would typically, if that does happen, we typically, we would have a maintenance and covenant agreement. It's still in the right of way. Anything happens, we still have responsibility for it, even if you have insurance indemnities. And so it's always a preference not to have that.
It says the grading plan shows 1-to-1 manufacturer slope within the straight right of way, and this was the preference of the city engineer because it avoids the construction of retaining wall within the right of way that would then need to be maintained by the city. My question was, why not allow them to do the 2-to-1 and have the maintenance burden as to run with the land with the applicant?
I don't know. I guess staff would have to answer that question. I think it's to have consistency with the guidelines, although.
I mean, I think it's possible to impose that as a condition. I think the city attorneys and what Mr. Garcia was alluding to was, in reality, in the real world, it gets very messy and difficult to actually enforce and actually maintain it that way, with that imposition on the owner when the walls are in the right of way. Is it conceivable? I suppose it is.
Thank you.
So, to
Ms. Lundergan.
carry off on Mr. Osterian's line of thought here, has the city's suggested design increased the amount of cut required?
Yes, essentially, the grading is larger than would otherwise be required with the use of the retaining wall system.
So is the
and
city
frankly-
not subject to its own laws of the hillside ordinance?
Well, it does put us at some conflict between planning and engineering, with engineering looking to try to save the city money and maintenance expense, and the planning division trying to enforce the rules of the hillside ordinance. This has been one of the many sticky problems with this proposal, and
That's what I thought.
has led to delays and led to problems. Even now, as you are debating it amongst yourselves, not fully resolved.
So has this really been the biggest issue, say the elephant in the room?
I don't think this has been the biggest issue. It is an important issue. This tension between these two competing desires of the city. I still would reiterate the big elephant in the room is the question of whether or not to allow a subdivision of homes in a secondary ridgeline. That is the elephant in the room. Okay. It may meet the criteria, the detailed criteria. It may be, in fact, that the environmental conditions have not substantially changed. But does it meet the intent of what the city wants to happen in the secondary ridgeline? I think in the past we may have taken a more we certainly obviously took a different view of that, but whether it met that intent. And the city was willing to support that in the past. It is my opinion that we should not support that this does not make sense. It is not what is reasonably necessary for the enjoyment of the use of the property. The city is not bound to approve a subdivision, fundamentally, of land. That is within your discretion. This is not a ministerial action. It's not merely that the applicant has to cross the check boxes off, and once he's done that, we are bound to approve it. That is not the way it works with subdivisions or any other discretionary action. You may, in fact, and the city has, in fact, approved environmental documents and then denied a project. The environmental documents may prove little or no impacts, or they may prove impacts that the city decides are unmitigatable and accept the document. But the city still has within its authority, despite the environmental review or despite these criteria, to reject the application. And I would again assert that is the appropriate decision in this case, because it is simply not reasonable under the current view by the city council and by staff that this is reasonable development.
Okay, thank you. I have one more speaker card. Mr. Sako Marcusi.
Yes. Good evening, Mr. Chair and members of the Planning Commission. My name is Sako Marcusi. My address is 320 West Arden Avenue, Suite 120, Glendale. As you heard, I've been involved with this project since the inception of it in 1989. Did some initial studies and went through these iterations of subdivision, 3 lots, 2 lots, and now we're here. In 2007, I had a design review board submittals, and I had approvals for 2 structures about 20% larger than what we have right now. And we had subterranean garages. Well, actually, the only thing about the 2-story at that time was that the garage was at the lower level, creating an easier access from the driveway to the garage, and the building was sitting mainly on a graded pad, and part of that building was sitting on top of the garage. So that's the difference from then to now. A question was raised about the height. We don't have an issue with adjusting the height to 15 feet. It's a single-story house, so we shouldn't have a problem doing that if that's one of the conditions that we should meet. And there were alternatives or suggestions made in the staff report that a one single-family dwelling development is more desirable. But let me tell you that, that would probably have a larger impact on the site itself. I did a quick calculation, and we have roughly 3.2 acres, which is about 139,000 square feet. At the lowest range of the floor area ratio, if we take 30% of the first 10,000 square feet of our lot, that's 3,000 square feet. In addition to that, considering that the slope of the lot, which is, I think it was a question, but I'm figuring let's say if it's over 40%, then the remainder of the lot area times by 10% of that would be 12,900. So we can practically by code build a house which is 15,900 square feet. Obviously, we're not going to put that there, but we could put a house there which is 8,000 square feet, which would have a larger impact on this property than what we're proposing right now, which both homes, which the mass is divided. There are smaller masses on the hill. There's a 20 feet landscaping between the two the house, and the homes are less than 3,000 square feet each. So I think this has a lesser impact on the property itself than if we were to do a single-family home. So I'm just making a simple comparison. So I believe you should also consider that. But preferably, this is what we like. We like to have the two homes there, smaller ones. Basically, right now, a modern living for a family of 4 or 5 requires, 3,500 to 4,000 square feet. These homes are, one of them is about 3,100, the other one is 2,900 something. So we're not really asking a whole lot.
Affluent family of.
Well, you put it that way.
Questions from Mr. Marcucci?
Do you have any questions from me?
I have one.
Sure.
You went through, obviously, a very extensive exercise to modify your plans.
Correct.
Bringing up the house and all that. Was that done with communication with the city engineers, planners, or was that just on your own?
What the communication was not directly, but with the engineering, but it was directly with the planning, because I had to go through steps of preparing my plans for submittal to design review, and that takes meetings with the staff, getting their opinion on the type of the.
I'm going to rephrase my question. Then were you given direction from the city planning department to, you actually went from 2-story structure to 1-story structure?
Right.
That was your modification.
That was the modification.
Was that direction given from our staff?
Yes. I'm not sure if you could call it, but it was a condition that one of the concerns was the building was higher than 15 feet, and it needed to be a 1-story and 15 feet. But I can argue that even that earlier version of my project still complies with the height requirements, because the code indicates that at the time of the construction, they're taking the natural elevation of the natural grade, and you measure from there to the highest point of the structure, and a garage access or a stair access to a lower level is exempt from that height limitation. And I was maintaining a height of 15 feet above my finished grade, but the only thing higher than 15 feet was the fact that I had a subterranean garage. And in my 30 years of practice here, codes have changed several times. I've been in the zoning committee several times. I know for a fact that the way that you measure height is not from where you enter the garage, but from where the actual building is in when you have a subterranean condition.
Well, the fundamental issues here, the question is that whether we can subdivide on the ridge line here, and you had proposed, 2 lots and obviously 2 structures on this lot, with the designs that you went through the modification. So, in your communication with the city staff, what was that discussed at all?
No, I don't think. I mean, the subdivision was never an issue with the planning because I was not at that end of the project. I was basically designing 2 structures for a lot who was proposed to be subdivided to 2 parcels. And that's what I was doing, designing homes that would fit on those parcels.
Ms. Landrigan.
One of the other questions I have is that, was there ever discussion from the planning department that this should be a one-house lot? When you came in with it for the second time or the third time, this time, let's just say.
No, never at one time it was
That was
discussed
never
with me.
discussed that instead of 2, this would be more appropriate as a single family.
Yeah. At the time when I was designing the homes for submittals, that was never discussed. But in our latter meetings, when I had meetings with the staff after the project was denied, after the 2007, when the time lapsed on that, I was sitting in maybe 1 or 2 meetings with the staff and my client, and that issue was brought up that they would prefer a single-family development, one lot.
So when was this?
That was a few months
2008?
ago, maybe
A few months ago?
a few months ago, yeah.
When you came back in.
Yes.
So before August 4th, 2010, which is when you
I think,
submitted.
what was it? Is it January? I think January of this year, yes.
Thank you.
Sure.
Thank you.
We have
More questions?
Any more questions?
Okay, thank you.
We have a rebuttal from the staff.
I would only say that I think when Mr. Danielian,
Mr. Chair.
Yes.
After Jeff, then I wanted to add a couple comments to some of the issues as well.
after Mr. Danielian, well, when the map was about to expire, we tried to explain to him what the problems were, that his plans at that time, this was in 2007, he could not demonstrate that he was in compliance with all the conditions of approval at that time. There was one key condition that he would have to obtain a variance for the project for some slopes and retaining walls that were not in compliance with the code, and there was a condition literally that said you had to get a variance before you could build the project. And there was no time for him to submit an application, go through the process, and obtain the variance. And we warned him about that, and when it came right down to it, we could not stamp the map the final map that he had submitted that he wanted to take forward because he hadn't complied with the conditions of approval for the map. I have told him and Hike both that we have long preferred a one-house proposal for the site, that 2 houses. Since I've been on board on the project, at least, I view the 2-house proposal as just not being consistent with the secondary ridgeline criteria, or secondary ridgeline intent. I don't want to say the criteria, but the intent.
And how long have you been on it?
Since 2007 is basically when I got involved. I helped process the time extension back, I think, was in 2005, but I haven't been involved with a new application until 2007 or 2008. And I was the one who was working with Mike Garcia at the time, trying to decide could we stamp the final map back in 2007.
Mr. Hamilton, the fact that you have a ridge line that is pretty much deteriorated, didn't that play any role in your opinion of, well, it's still, we're going to hold this thing to its strictest interpretation of the code, that a ridge line, a secondary ridge line, you cannot touch it, get close to it or what have you, deteriorated already, there is a pad created. Did that play any kind of role in your opinion of the matter?
To the extent that this ridgeline is already altered and is not natural anymore and doesn't have a bunch of trees on it, it's arguably less worthy of preservation, but that really doesn't enter into our discussion or my discussion. It's a visible ridgeline. It's prominent. It's not as prominent as a primary, but it still is a secondary ridgeline. It's been mapped by the city as such. And there's nothing in the ridgeline criteria that says if it's been altered, it's not worthy of similar consideration. So we can't really use that, I don't think.
Mr. Garcia, you had comments.
I apologize. One, I wanted to echo the comment that Mr. Hamilton was making with regard to the expiration of the map. The MAP Act has some very strict guidelines as far as when you submit your map for approval to get the final map. It's actually supposed to be in a condition where the legislative body, meaning the council, can approve it within 20 to 25 days. I forget what it is. And it just wasn't in that condition. As Jeff said, it needed the variance, and it was an impossibility to do that. The second thing I did want to address, because it was mentioned regarding the environmental document and how that relates to the findings. The CEQA does say that when you compare a project to a land use plan's guidelines to determine whether there's consistency, and that's one impact. But it really goes to the provisions of a particular land use element that relate to the protection of the environment. And what the staff's comments are with respect to the project have to do with the consistency of the project with other goals of the land use element, zoning code, and design guidelines as it relates to site design and compatibility. So the fact that the environmental documents found, and it's not, I don't have it, so it would be a good issue to have to maybe look at it more fully. But just because the environmental document was approved doesn't mean that the Planning Commission doesn't have the authority to say it's not consistent with the guidelines as it relates to site design, compatibility, those types of things. So I just wanted to make sure that the record was clear on that.
Thank you, Mr. Garcia.
May I ask Mr. Garcia a question? Mr. Garcia, the variance, was it known at the very beginning of the granting of the tentative tract map that variance was going to be needed? And so if it was...
No, it was a written condition of approval.
So the applicant didn't have sufficient materials to go forward to apply for that?
I'm not sure why they hadn't, but they hadn't, and that's the point. At the time they submitted their map,
they didn't do their due diligence in pursuing that variance.
They didn't show they could comply with the condition.
Okay. No.
Right now.
Not,
Just wait.
we'll call you. Yeah. So,
The one other thing I would point out is that if you feel, and Mr. Garcia can correct me if I'm wrong, if you feel that the environmental analysis that's included for this staff report, or if you would wish to approve the project, and you don't feel the environmental documentation is sufficient or is accurate, you can order that additional review and revision be made to the environmental documents. We've asserted in the staff report that we think it's reasonably accurate, but if you're not comfortable with that, and if you want to proceed, then you can ask staff and the applicant to work on revisions to that. We have not, as staff, spent a whole lot of time thinking about the environmental impacts because it was pretty clear from early on that we were going to recommend denial. And if you choose to go in a different direction, then that may be a course that would have to be taken.
If I could just clarify that or add on to that, because I agree with that. 2 points. One is that as it relates to if you agree with staff's recommendation that it's not consistent with the design guidelines and therefore you wouldn't need to do that. But I would suggest if you wanted to approve it, but you still have concerns about the environment, you'd actually need some evidence to give us why you think we'd have to go. It wouldn't just be you disagree. It'd have to be some evidence, substantial evidence, really, to go back and change the environmental. That's what CEQA says. Once it's been done, it's been certified. You need substantial evidence to say no, it's no good. It's no longer good. You got to go back and do some additional review. So I just want to make sure the record's clear on that as well.
okay, thank you, Mr. Garcia.
If I may add just one point, again, as you know, to emphasize that CEQA impacts are not the same thing as not meeting the hillside design guidelines. Staff is recommending approval of one exception to design guidelines of not providing the two on-street parking bays, but we didn't call that a significant impact under CEQA. I assume that the applicant's happy with that. So it's just in demonstration, those are not the same things. I mean, if you're saying that if you say something's not an impact, therefore it must be consistent with the guidelines, then conversely, if we're approving an exception, we would have to require an EIR.
Thank you, Mr. Foy. Any more comments from the staff? Okay.
One question for staff.
Mr. Schitz.
Mr. Hammond, clarify for me the variance issue that was required by the MAP Act. That was required to be done before we went through the process of the subdivision.
No, not quite. For the last map that expired,
Okay.
there was a discrepancy between what the applicant proposed to, how the applicant proposed to grade and install the retaining walls, especially near the street, and our standards for retaining walls and grading in that area. In fact, the map proposed did not conform to our standards for slope and height and configuration of retaining walls. So we said, yes, the city said, we'll approve the map, but as a condition, you're going to have to alter the plan to demonstrate compliance, or you're going to have to apply for a variance from that site planning standard for slope and retaining walls. That was the requirement for the variance was a condition of the map to make it conform to the zoning. When the applicant, Mr. Danielian, submitted his final map, desperately hoping to record it, there was not enough time, and he never actually made application for the variance necessary, but there was no time in any event to process the variance application, even if he had brought in the money and brought in the application and all the materials. He waited too long to submit that to the city in order to effectuate all the conditions of the map. And we are not allowed under the Subdivision Map Act or in the city's, the way it's adopted by the city, to approve and take to council the final map if all the conditions of approval pertinent to the map haven't been complied with.
Can you tell us what exactly the variance was?
I would need a few minutes to go find the file and get the wording. I think Ms. Stotler actually helped work on that.
If you remember.
As I recall, it had to do with the slope behind the retaining wall that was right by the driveway, right where it meets Rafael Terrace. And there's a provision where retaining walls had to be a certain height and the slope had to be a certain percentage, and I don't recall exactly.
I think it was required that the slope be 2-to-1 and the retaining wall not be taller than 3 feet within 5 feet of the property line. And I think the retaining wall was too tall and or the slope was too steep in this area. And it was only one sort of limited area of the property, but it was not in compliance.
Correct, and that's exactly why it was made a condition of approval, because at the time it was felt, well, there's some flexibility to hear, and also at that time some time, because the applicant had the full time of an approval in which to remedy that, so they could either redesign it or they could apply to obtain the variance. So at the end, when somebody comes in for a final map, there's a certain check that goes through, a process that we go through, where we go through a checklist. We look at absolutely all the conditions of approval. And at that point, it's basically ministerial. We don't have the option to change a condition. When we go through conditions of approval, it comes right out of state law, you have to comply with every single condition of approval. And we weren't able to show that the applicant can meet that condition of approval. Therefore, we have no option. We cannot have a final map if you don't meet all the conditions of a tentative map.
So excuse me.
Scared me.
So had they proposed the plan they have now, they wouldn't be required to have a variance, likely.
Yeah, if there's a zoning issue right now in the map that they're showing, then yes, they would need to remedy that. That would be a similar condition of approval if there is anything that's a discrepancy.
But in the current submittal, I have not found any things that are contrary to the zoning regulations related to site planning, retaining wall height, etc.
So, guys, you had a comment?
Well, I was just going to say that those conditions, I mean, the issues with respect to the prior map, that it was a different case that did expire. At the end of the day, it's the Commission's role to decide whether it believes there's evidence to support the determination that the project is consistent with the guidelines or not. And that's kind of
Thank
where
you.
we're at.
Thank you, Mr. President. Applicant has a rebuttal chance.
If I may ask one more question,
Mr.
Mr. Hamilton. 2007 was when the current map expired, correct?
Not quite. It's when the last approved map expired.
Right.
Not the current map.
I'm sorry, the last approved map expired in 2007.
Yes.
Between 2007 and June 15th of 2011, have we had any changes in our guidelines to the hillside ordinance in regards to secondary ridge lines or anything of substantive nature that we need to know about right now?
I'll defer to my colleagues sitting on the other side. I do not believe we've altered any of the secondary ridgeline criteria in that period.
Okay. Thank you. Okay, any more questions?
One last question.
Yes, Ms.
And actually a
Lindberg.
comment. Thank you. I'm looking at the motion that Ms. Permian gave us. Thank you. And it does state that it's a 3-year extension. And it makes very clear that the findings made by the Planning Commission in its decision on November 19th remain applicable today. And the conditions in the neighborhood map have not changed to warrant reconsideration of the original approval. So they had 3 years more to deal with the variance that was going to be required that they didn't meet the intent of until the very last moment. So I think that's something we should think about.
Thank you, Ms. Landovan.
May I see that?
You have 15 minutes rebuttal.
I just want to make a correction that we never had any issue of variance, Mrs. Landregan. Nobody told us that we gotta have. But when we submit the when we got the checklist from engineering and planning department, we went through on everything, and the engineer submitted to the engineering department. He got the approval, and then he submitted to the planning department. He got the approval, and before the expiration, 2 months before the expiration, I did talk to Mr. Hamilton, and I said, "What else do you need? We have 2-3 months for expiration. What can we do?" And he said, "Those are the checklists that we need in order to finalize the map." And I paid overtime to the attorney to get the CCNR because he wants the CCNR by this date. So I paid extra money, attorney overtime, Saturday, Sunday he worked in order to provide him Monday or Tuesday the CCNR. This is happening 2 months before the expiration. If there was a variance issue, Mr. Hamilton should have told us or told the engineer. Engineer is working 3-4 years, and every day he's going back and forth between engineering department and planning department. Planning, engineering. Engineering is happy that they're always happy. The planning wasn't happy. And finally, we got that resolved. But to answer to your question, nobody from planning department told us that we need the variance. And as a matter of fact, we did have the stamp. If we did not have the stamp, why should I spend pay overtime to the engineer? Why should I pay for the bond, survey municipal bond, $5,500? Why should I pay cleanup bond, $2,000? All these fees I paid to the city of Glendale to get the grading permit, and I did get the grading permit. I spent more than $30,000 to engineering. I spent more than $20,000 to architecture. If there was any variance issue, if there was any other case or question or whatever, the planning department, they could have told us. Why they waited in last minute? And correct me if I'm wrong, Mr. Hamilton.
Well, thank you for your...
You may ask that question.
Right.
Well, if that was,
I think I said Mr. Garcia at that time.
if that was the issue in the last one, what was the issue in the first 6 years, the 1993 approval?
First 6 years?
Yeah, you had 3 tract maps approved 1993, and then it expired in 99.
Okay, the issue was the engineering. I was so busy with my business, real estate and development, so I trust the engineer, and the engineer just delayed. And honestly, I didn't know that this subdivision process is going to take 2-3 years to get the final point to record it. Okay? And I'm taking that responsibility, so I should have been on top of the engineering. So we changed the engineering, so we got one of the best, and we pushed it. Yeah, that was the main reason. And maybe the economy was, that time we were in recession, so I wasn't maybe willing to go faster than economy. So I just slowed down a little bit, and I didn't know that it was going to expire. And also, I didn't know the second time when they extend this, Mr. Hamilton said I could have gone 3-year extension, but I did 2. No, nobody told me that I could have 3 years. If I had 3 years, then by 2008 I was finished the project, the approval or whatever. So there were a lot of things that I wasn't told, and we didn't know. But the bottom line is that we had the project last 20 years, and this is the only project in secondary ridgeline. Remember, this is the first project in last 20 years. So it was approved for 3, it was approved for 2, and there is no changes to the lot, and there is no changes for ridgeline requirement or any other requirements. And with this design, the neighborhood is going to benefit a lot. They're going to have wider street, they're going to have a fire hydrant, and I think this is the perfect. In the last 20 years, we designed and redesigned, and you have perfect design. If you don't want 2 houses, I'll go ahead and build 10,000, 15,000 big mansion. Would you like that?
Thank you, Mr. Daniel.
Thank you. So I'm hoping I'll get your approval. Thank you.
Any questions? Okay, so we want to close the public hearing.
Can we have a quick break?
We'll take a 5-minute recess.
Prerogative of the chair.
Hearing. Just one more time for a quick question, since we got this new material.
Do you have a copy of that too, Mr. Chair?
Did you make a copy for the applicant?
I didn't have time.
I'd just like to point out to the commission that because there's questions have been raised about what happened in 2007 and what were the conditions of approval of the last approved map. I've made a photocopy of the motion approving the previous map, and then our letter of 2007 explaining to the applicant why we could not approve the final map.
Mr. Hamilton, for the record, public hearing is open.
Okay, sorry.
So these conditions, these 5 conditions you have on page 1, probably be a good idea to get a copy to them as well.
I think Mr. Garcia just passed a copy to the applicant.
The 5 conditions, those were the conditions attached to the original approval in 2001?
Yes, that were not met.
Okay, so those conditions went along with the 2001 approval of the tract map. So they were aware of these conditions.
I may not have reminded the applicant prior to the
conditions were
expiration.
attached to. I just want to make sure
the conditions were part of the map.
To the approval.
Absolutely, yes.
And my chair is going out of control.
we have any more comments or questions? Okay. Close our public hearing. We're going to deliberation. Who would like to start? Mr. Schitz. Yeah, Mike is not.
Sorry about that. Deliberations and issues that have gone over a long period of time create some real challenges for everybody and especially the commission. And it's a real difficult task, at least for me, to try to balance all the issues. We have all of the factors that happened in the past, and they have a bearing on the case. But we're dealing with the case today and the factors that we know about and the evidence that we have today. So it's, for me, it's a balancing act to try to think about all of those and then work towards a decision. The factors I'm seeing over this case right now, just to explain to you where I stand. We have the issues on the property side. The lot was graded. We don't know when. This project was approved. The map was approved twice, and then expired. For me, the intent and continued pursuit by the owner has been admirable. I think that the owner has tried continuously to be compliant on all issues, or at least on most issues. I have some concern about the conditions that were not met. But then on the other side, I'm thinking, just because rules were overlooked during the original process and the environmental did not mention the hillside ordinance, doesn't mean it can be ignored. I also worry about the precedent issue that comes with going beyond and ignoring existing conditions and rules. And for me, at least at this point in time, I don't feel currently that this project is consistent with the intent and purpose of the Hillside Design Guidelines as adopted by resolution of the City Council. Now, having said that, I need to hear more information from my colleagues. It doesn't sound to you like I'm on the fence about this issue. It does to me. I want to do the right thing. I care about the time that's been put in by the appellant, by the owner. I trust and value all the input he's had and all the backup and professional support he's had. But I have some real concerns about following the rules and following the guidelines that I feel are important. So I'm awaiting further input from my colleagues on this decision.
If you like to, I
Mr. Storius.
What I want to, the first thing I want to do is I want to reiterate a couple of positives about what we've heard and what we've read in the staff report, which in my opinion would weigh on my decision as we go forward. Number one, per unit acre, it allows to have 3.60 versus the proposed 2.0. There's two dwellings versus the 3.60. That's a positive for me. That's less impact for the neighborhood. By the way, I'm not seeing anybody concerned from the neighborhood to begin with. Number two, prior to this new proposal, 6,580 cubic yard of earth was to be moved versus the 3,200 that it is today. That's a positive to me. Number three, it's again proposed 1.56 versus allowed 1.128 per acre as it allows it. In fact, the staff, as Mr. Foy suggested, did not have any problems with the exception for the street parking bay. In fact, the staff supported it, that if it's not there, it's okay. The They have worked diligently for the last 10 or 12 years on this thing. And I want to introduce perhaps, and I know Mr. Garcia will stop me when he thinks I'm overstepping the introduction of what I'm going to be introducing you. But in planning, there is something called as the highest and the best use of land. And by putting restrictions on that principle, which is a fundamental principle in planning, and that goes with, is it legal or allowable? Is it physically possible? He's talking about the development end of it. Or is it financially feasible? It means the developer has to be able to turn a profit on it, whatever it is. And then that's these principles, the four principles of highest and the best use of land, play a great role in land use decisions, period. I am thinking, if I were to take the two dwellings, which is modest to begin with, in my opinion, and take the two and instead insist on one, are we taking away the principle number 3? I know this is a planning principle and so forth. So these things weigh on my the kind of decisions that I am about to make and haven't yet. Just like Mr. Sheets, I'd like to hear the rest of my colleagues as well.
Sand?
Well, this, like some cases we get, is a complicated one, and it's one that we had before and we have now, and it's had a very long history, as we've seen. There have been approvals, and the applicant has had a lot of time. The first approval was 6 years to do something, and then the second approval was another 6 years, and there were extensions in that time. There were also denials as well. So, with approvals, there have been denials throughout that history. So, while I can see from the applicant's point of view that, he is trying to make his best use of his property, it has been a complicated time, and the city has not been very clear. Even at that time, they have gone one way or the other. And at the same time, we have this hillside ordinance for a purpose, and the intent of it is obvious, that it's discouraging development. Every time I drive up to, up in the hillsides, I am just thinking it's a little bit crazy living up here, and I understand why, there is hillside ordinances like that. Why we might want to discourage is because, every house we do build, it causes more stress for our city services and, fire and things like that. And while there hasn't been new ordinances on the hillside since that time, we've done a lot of amendments to our general plan to encourage more developments in our downtown area. And we've been more focused in the downtown area and, centralizing development, doing smarter development because of that. On the other hand, it is complicated. It's not the easiest thing because, the definition of reasonable development is not always easy to define. On the look of it, this may be a reasonable development. Also, the complicated issue I face is that, if he comes back with a single-family house as well, which I'm sure, even if it's a 10,000 square foot house, I appreciate the threat that, the 10,000 square foot house might be built, but we still have to approve it. And if we did not approve two homes, I don't think we're going to be approving that. But, even if it is a single-family house, with maybe 3,000, 4,000 square feet, it's still not going to be very easy to build. and it's going to be complicated. But my inclination right now, I think it's to not go ahead with it, just because the ordinance's intent is to discourage development, and even though we're not going to be doing, even though we're doing, if we do one home, that's one thing, but 2 homes, I don't think that's falling under the exact intent of it. And it's hard for me to figure out a way to get it past that.
Ms. Landrigan?
Well, let's go with the highest and best use. I think that's a nice thing to start on. Community vision sort of subjugates individual vision so that the community sets standards that all of us agree on and not everybody agrees on them. So that the ridgeline, secondary ridgeline protection history is that if you drive through the 2, and this is off of the 2, you'll see areas where there was no ridgeline protection, and it has been used as a bad example of doing hillside development all over Southern California. And we have changed our ways with the secondary ridgeline and the ridgeline protection amendments to the code. The other thing is whether we've had zoning or land use changes, the land has changed through natural processes. We have had a history within that time of 2 huge mudslides, one right off of Mountain that was engineered perfectly with a slope that's very comparable to this, and a retaining wall that's very similar to it. And we've had a fire through there. In '97, the fire probably took out all the trees and the shrubs that would have kept you from developing it. Thank you, Lord. So there are other things that actually guide us in the decisions that we're making. All of those said, I look at the development proposed and I see the history of the intent, and I see right now that there are no variances. The intent of the original approvals, and I'm going to go with the intent of the original approvals here. The intent of the original approvals is being met in extremely good faith by the applicant. The intent of the secondary ridgeline guidelines are very important, but it is an altered ridgeline, and I live in this area, not in enough to declare that I can't make a decision on this, but on the other side of the hill. And I drove down the 2, and I was trying to see how it would be affected, because I think a secondary ridgeline protection deals with views and vistas also. I mean, that is why we are protecting it. And if I'm oddly favoring the good intention and the good planning and the changes that have been made, despite some of the elements that I said, because I think that we now have in place, the fire department requires certain elements that will protect it from fires. Our engineer here is aware of the fact that the kind of soils that we have here, and that even the best engineering can be compromised by hydrologic forces, and so I'm sure that there have been changes in our engineering requirements. I wasn't real happy with the threat. It seemed beyond how gracious you've been, so I will disregard it, because I think that Mr. Danielian has really been very gracious, and his intent seems very honorable, and we can't always say that about all our applicants. And I don't take the secondary ridgeline guidelines lightly either. But I do feel that we are going to, the right to develop is an individual's right, and that this is done, and I think, in a very responsive way. And I think that if there is going to be a single family home there without 2, that it could be done responsibly, and we would do it at the same time. But I think that the history leads me to be in favor of this proposal as it is.
Thank you, Ms. Landrigan. My thought process on this project, obviously with, like my fellow commissioners went back and forth many, many times. One of the things that I was looking at, I mean, no project should go for 20 years, but all along, the applicant was working with the city on a lot of the changes, and that's one of the reasons why I asked, what was the process here? And obviously, either there was a big miscommunication, there was a disconnect. If there was no disconnect, then actually there were some guidelines given by the staff for them to work on this, improving their designs. And as far as meeting all those 7 hillside guidelines, they were doing that. Now, if there was no intent or there was no development that was increased along secondary ridgeline, then let it be. But our hillside guideline does allow development on the secondary ridgeline, whether it be single or the 2 houses. Now, one of the things that I had a little problem with is that if there was no subdivision allowed along secondary ridgeline, then this process really shouldn't have taken this far, this long. But it really bothers me, I think, to see this project come this far. And I think there should be a little bit better communication between the applicant and the city. My thought process goes along with Ms. Landrigan in that the applicant has put in a tremendous effort to comply with a lot of the guidelines, all the 7 guidelines that's been put forth before them, and I mean, does not mean that approving this case is not going to, it's not going to set the precedence of the future projects. So my thought is to actually allow this development.
May I add something?
Yes, Ms. Landrigan.
Thank you, Mr. Chair. I do think that the fact that we have 2 city departments that oftentimes have conflicting requirements and needs, and that makes it doubly hard. But I also support the engineering requirement that they set back the wall. I think that is the prerogative of the city to do that. And even though I think it's in conflict of what our existing hillside guidelines are, I think the city has that right, and it's prudent to do so. I also do believe that this is actually a very good example of good site planning. And I don't say that lightly, because I really think that a lot of times people don't look at the site and plan it very well. But this has been thoughtfully planned out, I think. You do have the existing pads. I think the concessions that have been made have been in a very good manner of looking at this as not as though this is only designed by a Caterpillar as your tool of planning. So to me, I look at the way that the topography has been addressed and the neighborhood has been addressed, and also the other views, and I do think it is good site planning.
I just want to make a quick comment, since I left my decision hanging. I want to mention that I strongly support the views of the staff and the perceptions and the presentation that they give relative to what we're talking about today. And I think the research was admirable. The data is factual and made me clearly understand, if that's possible with a process that goes on this long, what their intent was. But I think what's going to help me make this decision is there were other factors that could be perceived as adding confusion. So, but I strongly support the hillside ordinance. I think it's right, and I think we should do everything we can to follow it to the last word. But this process has gone on a long time, and I think there are other factors that will impact our decisions on this dais. So I just wanted to add those thoughts.
Thank you, Mr. Schitz. Mr. Story.
Mr. Schitz, I like Jeff Hamilton as well.
Not my point.
I want to
Not
just say
about
that,
Jeff.
I'm going to go along with it too, so we can be in full support of it. And generally, like I said, if it goes back into single-family house or what, it's not a guaranteed process if that's a reasonable development. So I don't want to be the lone negative person here too. So
I think what we need is the continuance, I think, to develop the language for the next hearing. And then also, there was the environmental report that was brought up, whether or not we're going to require, new study.
I don't think I need it.
I don't think
Okay.
we could make, I don't think that's a good
You
idea.
don't need that.
Okay, all right. So,
It's not required for the record.
okay, let's close the deliberation. And
Can I make a motion?
yes, please.
I move that upon consideration of the tentative track map number GLN 1625, and after reviewing the records, files, and reports and all documentary evidence submitted with regard to the tentative parcel map, that tentative parcel map number GLN 1625 is to be continued with findings to be made based upon our comments by the staff to bring back to us for approval,
Along with conditions of approval.
along with the conditions of approval that were precedent in the original.
Seeking support?
Second.
May I just interject?
Yes.
I would recommend respectfully that you continue to a date certain of July 20th. Is that the second meeting in July? Because I'm going to be out of town the first meeting of July.
And I recommend it to be heard on, to a date certain July 20th.
Okay.
Second.
Roll call, please.
Yes.
Yes.
Aye.
aye.
Aye. Vote of 5-0 is continued till day certain, July 20th, to develop the language for approval. The next case this is new business. The subdivision of a land, tentative tract number 71560, location is 1354 North Columbus Avenue. Staff report, please.
Thank you, Commissioner Lee. Actually, I'll be very brief. This case is not as complicated as the one you just heard. As you stated, it's a request to subdivide a new proposed two-story multifamily building, which it consists of 7 units over a semi-subterranean garage, and it's located in a transition zone, so you'll find that the building is actually situated or under construction on the R1250 site, and adjacent to the north is a small landlocked parcel which is zoned R1, and that will remain open space.
Didn't get that.
So, just to reiterate, lot number 39 is fronting Columbus Avenue. That is the rectangular-shaped R1250 lot. And lot number 40, and you can see that on the site plan behind you, is the square-shaped lot, which is 60 feet wide by 62 feet deep. That is the landlocked parcel between the R1 and the R1250 zone. There is a mitigated, actually, I'll rephrase, it's a negative declaration on file, so there is environmental review. There's also, actually it is mitigated negative declaration PEIF 2004-007, and that was actually approved back in September of 2004. And there is also a variance on file that was actually approved back in 2005 for the construction of the project which did not comply with the interior setback requirements. So again, before you, we have to subdivide the proposed 13,212 square foot, two-story residential multifamily building for condominium purposes, consisting of 7 units over the subterranean garage, which actually has private attached garages for 2 spaces, and then a third space within the same area is outside of the actual enclosed parking space. It's actually parallel.
And that's the guest.
It's a requirement for the units, and also the guests are outside the enclosed parking spaces. So again, they do have the required parking. They do have the required open space. The common outdoor area is 4,845 square feet, which does include the R1 open space. And just that alone, just the R1 open space is 3,714 square feet. And again, that is required to remain open. It was actually conditioned in the variance that they cannot propose any developments on the R1 property. Strictly open space, maybe some benches, landscaping. So staff is recommending that the Planning Commission approve the tentative track in accordance with Title 16 and the Subdivision Map Act, along with the conditions provided in the staff report. And if there are any questions, I'm available.
Thank you, Ms. Toledo. Ms. Lundergan.
Ms. Toledo, I have some questions on the R1.
Okay.
You said no structures. Does that mean they can't do any shade structures, that they could not do, like if they wanted to
A gazebo or something of that nature? That's correct.
So,
because that would be considered an accessory structure, and that requires a building permit.
And why was that put as a condition? Just as a landscape architect who designs spaces and knows that a large space like that a tree would be able to be planted, but...
Yes, landscaping, definitely. You know, going back to the year it was approved, I'd have to review the tape, but if I recall, there was, again, this case had some opposition.
Neighbors may have had.
Right. If you notice in the report, it was actually approved by the then Board of Zoning Appeals.
Right.
Because it was originally approved and then was appealed by one of the neighbors, which I don't believe is living there any longer. But anyways, it has no relevance in this case. But in any case, that was the condition that was imposed by the zoning administrator.
Thank you for that edification.
Any other questions for the staff? See none? I have one speaker card. Mr. Martirosian.
Good afternoon or good evening. This is Haik Martirosian. I'm tract engineer. Once again, my address is 1545 North Verdugo Road in Glendale. This subject properties consist of 18,380 square feet, and it's contained of 2 different zones. It's in R1 and R1250, as Ms. Lido explained that the density of this project is based on R1250. That's what we were allowed to have almost 11 units, but we choose to have 7. And portion of R1 is going to kept as open space with some benches and landscaping to have tenants to be able to use it. Unit ranges are from 1992 to 2022, and there are 3 bedrooms and 1 4 bedrooms. And there are 23 parking spaces available. Each unit has its own private garages, which will have access through their own units, plus additional parking spaces on the site. And there are 2 guest parking provided for the tenants also. I have read the conditions, and the property owner has read the conditions, and we are all compliant with the conditions, and we will concur with the planning staff recommendation. If you have any question, I'll be more than
Any
happy.
questions, Speaker? I see none.
Can a pool be put in there?
I'm sorry?
Could a pool be put on the R1 section? Is that considered
planning,
a structure?
Can you come to the podium? State your name.
I'm the owner, Henrik Sargisian. My address, 739 Wing Street, Glendale, California, 91205. We have a plans to prove everything, but we're not going to pull there.
Okay. Thank you.
Any more questions?
So this is, I have to say, I drove by it and I saw the property. You know, it looks like it's almost done. It looks really nice. This is one of those cases, again, that, you know, they build and then they come to get the, the subdivision, which is a little bit funny.
It's being
And
done.
this is,
It's being done all the time.
I know.
They actually could come after, turn it into, you know, propose a condo conversion, a conversion from
Stay as
an
an
apartment
apartment or
building
condo
to.
conversion? Right.
The City of Glendale conditions for apartment and condos are almost similar. There is no different between those apartments and condos. That's what time they start the process of.
Yeah, you can get the permits and stuff.
They obtain the permit and it will take them time to construct while we are in subdivision. So
Or is
hopefully by the time they finish the construction, we'll be able to record our map and make everybody happy.
It's market driven.
It's conversation.
And how do we get two of your cases in the same
Lucky
night?
man.
Eerily familiar.
On the same day, you know? Good plan.
I don't know.
You know,
Just
people like you here.
Just the charming law.
I was just going to say, this conversation sounds eerily familiar. I think we did this the last time he was here, about the last one, so.
Thank you.
No more
I have no
questions?
more
Okay.
questions.
Staff? I'll close the public hearing. I'll entertain comments, motion.
I'll do it. I move that upon consideration of tentative tract map number 71560, and after reviewing the records, files, reports, and all documentary evidence submitted with regard to said tentative tract, that tentative tract number 71560 is hereby approved, subject to the compliance with the State Subdivision Map Act, Chapter 16.16 and 16.32 of Title 16 of the Glendale Municipal Code, Title 30 of the Glendale Municipal Code, and 35 additional conditions listed below. And the Planning Commission hereby makes each and all of the following findings as stated in the motion before us.
Seeking support.
Second.
Roll call, please.
Planning Commissioners Astorian,
Yes.
Landrigan,
Yes.
Sheets,
Aye.
Yesayan,
Yes.
Chairperson Lee.
Aye. The vote of 5-0, the subdivision of land, tentative tract number 71560 is approved. Planning division updates.
Commissioners would like to extend congratulations to Mike Garcia. He is now our new city attorney as of September.
Yes.
So that was a nice appointment by council.
Thank you very much, members of the commission.
Does that mean you're going to leave us now as far as our regular meetings?
Probably will have to have other attorneys assigned to the commission, which is odd for me because actually since I've been practicing law, I've been advising at least one planning commission.
Great.
My entire
We
career,
appreciate
so-
all your help in this capacity.
Thank you.
And then for other announcements, we do have the North Glendale Community Plan that will be brought to you at the next meeting. For those who are interested, we do have a community meeting, which is scheduled for the Spar Heights Community Room on June 29th. And so that's open to the public from 6 to 8 p.m. And so we're encouraging anybody who's interested in learning about the North Glendale Community Plan to attend that community meeting.
What day is that?
It's Wednesday,
29?
June 29th.
29.
Wednesday, yes, Wednesday. And then we also have two appeals which will be brought to the Planning Commission. We have 3431 Linda Vista Road that's going to be brought to you, that's scheduled for July 20th. And then we also have an appeal at 117 South Louis Street, ASCLA, that's going to be scheduled for July 20th as well. And you're also on July 6th, we do have another appeal, too, that was scheduled. That was one that you had continued to July 6th. That's the appeal at 1017 Cumberland Road.
The North Glendale Community Plan, that's the only case we're hearing that one day?
No, actually, because the appeal was continued to July 6th, you're going to have an appeal and you're going to have North Glendale Community Plan. That would be your next meeting.
Which one was Cumberland?
Cumberland is a single-family home where they've asked for variances for FAR and for a setback.
Okay.
Thank you. Comments from commissioners?
Yes, I do. And this is for Ms. Stotler. I had a conversation, without going over the case, the first one that got continued, about the report, the staff report, and the reference that was made to processing and catering almost in the same breath. And I just wanted to, and you had told me that there is some work being done on it, food processing we were talking about, and catering. It seems to me that these two are a little bit different as far as the applications and so forth.
Mr. Estrella, should we discuss this when we hear the case?
If you so show, if
Which
you
case
so
are you-
choose.
Unless he's asking for a definition
This
of
is,
the
yeah,
two
for
of
the
them.
zoning. It's in the
talking
zoning.
about a
We can discuss it when the hearing comes up. I would say that the issue of the catering was not something that the commission was going to actually be called to decide upon. It was just an issue whether they could be a banquet hall.
Okay, thank you.
And, okay.
Any other comments? I have a comment. The former chair, Mr. Bilken, did such a good job. This is a big shoes to fill, and it'll probably take some time to get up to speed to his caliber. But I thank you very much, fellow commissioners, having faith in me, and I'll do my best to live up to your expectation. Thank you.
Well, congratulations.
Congratulations.
I'll entertain a motion to adjourn.
So moved.
Okay.
second.